Well, good afternoon, everybody. Welcome to session 71. This will be a 5-hour lecture. There we go. There we go. Is everybody having fun? All right. I'm going to go off script for a couple seconds. I just want to make sure you're all engaged. So I do hope you're all having fun and enjoying the conference. There's a lot to actually take in. Get those legs working, track your fitness, on your own personal app too. My name is Brian Lane. I'm the president and CEO of the second oldest hospital association within the world, actually, and that's the Center for Health Affairs based out of Cleveland. And also run CHAMPS GPO, which is one of the larger GPOs that's out there. I want to welcome you today to this unique session, and believe me, there's a lot of discussion about the topics that you're going to be hearing about today. And it's entitled, A Confusing Muddle, Health Policy Post-Dobbs. Before we begin, I need you all to keep in mind that if there's handouts for the session, you can access them via the HIMSS 23 mobile app. Everybody have that on their phones? Good deal. All right. The evaluation for this session is located on the same session details page by clicking the Survey tab. Thumbs up on that? Perfect. We ask that you please complete the evaluation because your feedback is instrumental in helping HIMSS continue to deliver quality educational content. Finally, in order to claim the continuing education credits, which most of you are in here for, right? You're going to need to tap on the 3-bar menu icon on the left-hand side of the screen. Select about HIMSS 23, then Discover, then Continuing Education Credits. Everybody got that? All right. You may also claim the credits by visiting the professional development page on the conference website and navigate to Continuing Education Credits. All right, so now I'd like to introduce our speakers. Joining us on stage today, we have Matthew Fisher, General Counsel of Carium Inc., and Oliver Kim, Adjunct Professor of Law, University of Pittsburgh School of Law. Give him, as well as Matthew, a quick round of applause. They put a lot of time into their presentations and their lecture today for this 5 hours. The next thing I want to do here is I'll turn it directly over to Matt, let him kick things off. We will be giving the presentation for about 45 to 50 minutes, then it'll turn into a Q&A for 10 to 15. The mics are in the middle. Get your questions ready. Hopefully you've got a bunch. That's it. It's all yours.
All right, thanks, Brian. So if there aren't questions, we can do it reverse. We can go Socratic method since we're both lawyers and we went through that in school. Can give you a little taste of what we had to do way back when. Yep. Oh well. So maybe not. All right, so I guess quickly say neither of us has any conflicts of interest. So the agenda today, we'll try to keep it going, but first Oliver will go over our learning objectives, then we'll do a summary of kind of the key Supreme Court cases that touched upon reproductive rights and where we stand now. Then we'll go into responses from the administration level, from Congress, and then the states, and then we'll go into not only what should digital health be doing, but also kind of what impacts are on care delivery. So it could be a digital health company providing care, or we're seeing some impacts on physicians and hospitals and other groups. So I'll turn it over to Oliver for the learning objectives.
Should I stay? Yeah. Hi, everyone. Thanks for joining us. As you can see, our 3 objectives are, we want to first identify primary challenges to healthcare data from the Supreme Court's decision in Dobbs. We're going to outline impacts on access to care and information systems from new and conflicting legal requirements that are coming up at the state and federal level. And at the end, hopefully we'll have explained pending or recent policy developments that influence healthcare operations. Should we take turns going?
Yeah.
All right. So first, we're going to start with a foundation on just the jurisprudence at the Supreme Court, so everyone has sort of a level set. So we've highlighted here the three main abortion cases that have come up before the Supreme Court. Obviously, these have been in the news recently, but the major case is originally Roe versus Wade, a case that was decided in 1973, 7-2 decision that found a right to have an abortion in the through what's called substantive due process in the 14th Amendment. There was this idea that there was a right to privacy for a woman to choose that. As part of that, though, the court said, using trimesters, there was a conflicting, a separate right that the state had vis-a-vis its ability to regulate health that would grow in sort of response to the woman's right, and in the last trimester, states would have more ability to regulate abortion. And so over the next 20 years, the lower courts came to different conclusions about what that trimester framework meant. And in 1992, the Supreme Court decided to take another case about 20 years later called Planned Parenthood versus Casey, who was governor of Pennsylvania. And in a plurality opinion, that means the majority of the court couldn't come together on a single agreement on how to wrestle with the issues. But in a plurality opinion, the court said, we're going to do away with trimesters and we're going to look at what's an undue burden on the woman and her right. The other important part of this case is that the Supreme Court also heard from physicians who said, well, Pennsylvania is telling me I have to say certain things as part of informed consent, and that is violating my First Amendment right, and the court rejected that. And over the years, we didn't put this in here, but the court has revisited in two cases, Whole Woman's Health and June Medical, like how far states could go in terms of adding different restrictions, whether they were solely political or whether they were health related. But finally, last year, we all know in the Dobbs decision, the Supreme Court ruled 5-4 that states would have the ability to regulate as they choose. It could even include an outright ban on abortion services within their borders. And Justice Samuel Alito had said, oh, we're just returning this ability back to the states, back to policymakers. And so this should be a pretty simple decision. But after 50 years of integrating abortion into healthcare without a national standard, there's obviously a lot of muddle in how abortion is regulated. And it's also going to have a big effect on digital health. So we're gonna now turn to the political responses at the federal and state level.
Yeah, so kind of, as Oliver said, the responses are broken into a few different categories. You have what the administration, meaning the presidential administration, has been doing to respond. Then you have congressional action, and we're going to focus initially on the federal congressional action, and then we'll get into what some of the states have been doing in terms of both legislation, ballot initiatives, and other developments. So from the president's perspective, the first thing that they did was turn to executive orders. So an executive order is something that the president can issue, but it's at the whim of that particular president. Because if you might remember, during the Trump administration, there were a number of different executive orders that were issued, and as soon as Biden came in, he unrolled a lot of them to reverse the policy or issue new ones to change what the policy is. So those don't really settle very much, and it's also they have limitations on what they can do because they can't wholly establish new law because they don't have that force. Remember, with the way that our government is set up is divided, each branch has its particular powers, so there's only so far that it can go, or that the president can go with what they're doing, and there's also only so much they can cede. But in this particular case, Biden issued 2 different executive orders about a month apart, one in July and one in August of last year. And they kind of basically just reset out the principles that he was going to operate under, and saying that we're going to protect reproductive rights, we're going to help ensure that people can access the medical care that they need to for whatever is necessary for what they're experiencing. The first one, kind of an interesting point, is it directed various agencies to explore ways that they could protect rights under existing law. We'll get into this in a little bit, but we might actually be starting to see some of those developments. I'm not sure if people might have noticed, but last week, a notice of proposed rulemaking was announced. Maybe it was officially published yesterday or today. With travel, haven't had a chance to check, but the Office for Civil Rights within the Department of Health and Human Services issued that NPRM for short, around making modifications under HIPAA around uses and disclosures of protected health information. The second executive order from last August kind of, again, reiterated the administration's beliefs, and then it also included a statement around interstate travel, saying that individuals have that ability to travel between the states to access care that might be legal in one state that is not legal in their home state, which is important because that was raised in a footnote in one of the decisions, saying we might need to call that into question. A different concurring opinion said, no, we absolutely respect the right to travel between states. So maybe setting up something for to be further addressed by the courts going into the future. So then the next part is, how are the agencies responding? So the agencies are also kind of a piece of the executive branch because they have the political appointees who are put into place by the sitting president. They are typically formed and operate under authority given through legislation, so they kind of, to some degree, sit in the middle. But we're going to focus on 3 particular agencies. We've got OCR, which I mentioned, FDA. Oliver will dig into what the FDA has been doing, and then the last one is we're going to talk about EMTALA, or the Emergency Medical Treatment and Labor Act, which is really overseen by HHS. We're kind of fudging a little bit because OCR is part of HHS, so 2 pieces there. So from the Office for Civil Rights perspective, as folks here might know, or hopefully know, that's the agent or the sub-agency within HHS that's responsible for enforcing HIPAA. HIPAA, important because we're addressing privacy and security of information. So early on, they had issued a statement around, because the initial concern was that law enforcement or other people would request PHI and that they would be freely divulged, and there was a concern that that would have a harmful effect on the privacy of someone's information. HIPAA does allow the information to be used and disclosed. If law enforcement requests, they have to follow particular processes. You can't just freely disclose. But kind of and this is why words end up being extremely important, within the privacy rule, it says a covered entity may disclose that information, arguably making it a voluntary, or not a voluntary, but making it a decision point of what you're actually going to do. So theoretically, someone could, even if the process was followed, say, well, it says I may disclose it, so I don't really want to. I don't think that has been challenged at this point in time, and with the proposed rule that came out last week, that might actually just fall by the wayside because the proposed rule is looking to not further, but to actually lock down PHI related to reproductive health care. I would say, from my perspective, there is one kind of circular problem within the proposed rule, which is it defines reproductive health care by referring to reproductive health without actually defining it, or without specifically defining what that means. So you might end up with some concern around what that actually means to the extent you actually get the proposed rule into final form. But then it's going to restrict the use and disclosure of reproductive health care if it's going to be used for an investigation or proceeding by really courts, states, or agencies. And if someone does want to request it, they would then have to submit an attestation. So basically a certifying statement saying, I'm not asking for the PHI related to reproductive health care for one of these impermissible purposes. My question in that I saw after my first read through of that proposed rule is, what happens with enforcement if someone lies in the attestation? I mean, kind of what the proposed rule says is the covered entity that received that request should stop disclosing the information, but what if the information's already been disclosed, and what are they gonna do to the person who lied in the attestation? I didn't see an answer in the regs, and I don't know if they'd really be able to have a clear answer in there. So again, as the rulemaking process goes forward, I suspect that there might be comments around that, and kind of we'll see where that ends up falling out.
Yeah. And then the comment period's still open, so people should feel free to comment if they have questions.
Yeah, typically you get like 60 days to comment. So if you want to participate in the government process, comments on rules, on proposed rules, are the perfect way to be able to do it, because you can do it from the comfort of your own home. And when that kind of comment period closes, you can actually go online and read all the comments that people have submitted, and they're actually pretty interesting.
Yeah. So the next area we're going to talk about is drug development under the Food and Drug Administration. I think when we put together our proposal, we were like, oh, we should maybe put this in as a small section. We didn't anticipate what would happen, and the Supreme Court is going to rule in this area this week. But as you may have known from a lot of press in the past month, there has been a challenge in Texas Federal District Court against the Food and Drug Administration's approval of the drug called mifepristone. Sometimes it's called RU-486. A lot of times I'm just going to refer to it as Miffy. But this drug has been around in the US, about 20 years. And the FDA, for a long time, had very strict labeling requirements on it that limited its use under what's called REMS, Risk Evaluation and Mitigation Strategy. But during COVID, the FDA temporarily suspended some of REMS requirement, and it's been looking at a lot of the evidence. Again, we have a 20-year history, and decided to allow its continued use vis-a-vis telehealth. And also, it created a new option for pharmacists to be able to get certification and be professionals who could dispense Miffy. So one of the other things besides the court challenge that we wanted to just know is, again, this state-by-state issue, a lot of these things are still being challenged both politically and legally. So, for example, you may have seen that 20 Republican attorney generals have written to a lot of the major pharmacies like CVS, Walgreens, and said you should not go forward with trying to certify pharmacies in our states. So that's going to create a lot of challenges for major chains for being able to dispense. And then, of course, in the last month, the ruling in Texas was that FDA actually shouldn't have approved the Miffy, that it failed to account for certain studies, whatnot. And that case was appealed. It went to the Fifth Circuit. The Fifth Circuit stayed part of it, but restricted FDA's ability to allow for mail order, which would be huge. And again, that decision has been appealed to the Supreme Court. Now, this isn't a ruling on the merits, on whether or not the FDA was right or wrong. It's what's called a stay, an injunction of should the ruling go forward while the courts are litigating, or the parties are litigating on the initial legal decision. So that is before the Supreme Court. Could happen tomorrow. We'll see. And then the other thing that we wanted to also draw your attention to was that one of the legal arguments that the plaintiffs made was on a law called the Comstock Act, which was passed in 1873. It's an anti-vice act, but the court used part of its, based part of its decision on this law. A lot of legal scholars assumed Comstock was unconstitutional because of Roe, and there's a question, it's called a zombie law. I don't remember that in law school, but did this law resurrect itself now that Roe is not good law? And that's gonna have huge implications for mail order or shipping products across state lines. And then the last thing that I wanted to know is that the FDA is also in the process of reviewing an application for over-the-counter birth control. So for hormonal birth control, whether or not that could just be off the shelf. And that decision is probably gonna happen later this year. So I'll turn it back.
Yeah, and then as we said, the final agency action that we want to cover is interpretations of EMTALA. So EMTALA has also been around for a number of years, and this is a very gross oversimplification of what it is. But EMTALA, it means if you go to the ED, so the emergency department, they have an obligation to stabilize you. They can't ask about insurance. They just have to treat you and get you stable. So stable means basically allowing you to get your health back to a condition where your health isn't in immediate jeopardy if you walk out the door. Or not if you walk out, because if you voluntarily leave, then you've relieved them of the obligation. But if they try to discharge you, they have to stabilize you. And there's also kind of limitations on being able to transfer you before they've been able to accomplish that. So what HHS did is they came out with an interpretive guidance saying stabilizing care might require delivery of abortion or other reproductive health services that potentially could be illegal under the state law of a state that someone is in. So setting up a arguably a direct conflict between federal and state law. Typically under our system, federal law, if it's addressing an issue, will control over conflicting state law because that's the nature of the federal system that we have. Obviously that's been challenged. So there were two cases, both filed in federal district court, one in Texas and one in Idaho. In the Texas court, they issued an injunction. So again, as Oliver said, an injunction is, it hasn't decided on the merits, but kind of the basic premise is there's a feeling that there's the potential for irreparable harm and a pretty good likelihood on the facts that they would win as the case keeps going. So they'll stop that particular law until it gets finally resolved. So Texas issued an injunction, but in Idaho, they did the reverse and issued an injunction on a state ban that was contradictory to the interpretive guidance. So I'm not aware that there's been any further action. There hasn't. I think with those competing decisions, they're in different what are called circuits across the country. So every state has its own district court or courts, and then the country is then broken into, or kind of, some of the states are grouped together in different circuits. So that's where the circuit or the court, the appellate level court is together. So typically, if you have competing decisions, they go up to the circuits. If you have further divides, then that's how issues typically get up to the Supreme Court for final resolution. But those haven't progressed. I don't know if they're just waiting on further guidance or further challenges. But that's kind of an open issue. Then the only other issue or kind of action of note on the EMTALA guidance was that there was reportedly HHS authorized an investigation into a hospital in Missouri over what was arguably a denial of services, but there aren't really any final findings on that either.
So we'll next look quickly at some legislation, both that's been introduced in the current Congress, the 118th Congress, which is divided. The Democrats narrowly control the Senate. The House is controlled by Republicans. And then some of the bills from the 117th haven't been reintroduced, but we expect them to. So obviously both parties in both chambers are introducing legislation specifically on abortion, but we wanted to also focus on, there are bills of general applicability on different topics, health coverage or whatnot. And so some of these will, of course, have impact on reproductive health services because they're general, so they impact all health services. And I used to work in Congress, and we always used to say, you should deal with abortion and reproductive health up front because it usually winds up tanking a lot of other bills because the parties can't figure out how to compromise on that issue and carve it out of a larger bill of general applicability. So, Congress has been for a long time trying to wrestle with how do you do a general privacy standard, what's just a national law on privacy. Last Congress and last year, they got fairly close with the American Data Privacy and Protection Act. That was a bill of general applicability. It tried to wrestle with some of the weighty questions of preemption, of who can sue, do consumers have a right to sue, whatnot. It passed out of one of the major committees, the House Energy and Commerce Committee, but it never, overwhelmingly by a vote of, I think 53-2, which is pretty unusual for something that complicated. The Senate never took up competing legislation because the relevant committee chair, Maria Cantwell of Washington, did not agree with the House compromise language. In the current Congress, she is still the Commerce chair in the Senate. So even though the House bill was bipartisan, it's difficult to see her being willing to move forward on a Senate companion bill. Besides that bill, of course, there's bills of specific to health privacy. So there's bills to try and address HIPAA, the privacy standard there. There's bipartisan legislation that would punt it to a commission to come up with new regulations. There's also been a lot of attention to recent news reports about telehealth firms, about hospitals, about how they're using healthcare data outside of HIPAA. And there's been some legislation on that. And then just last week, 3 Democratic senators introduced a bill called Upholding Protections for Health and Online Location Data, the Uphold Privacy Act. And this is a bill that's like general to health privacy, but it's interesting how they framed it in their press talking points. They really centered it around reproductive health care, not about some of the other issues that are happening in terms of health data and its use outside of HIPAA. And just on that note, there are a couple bills on specific to reproductive health privacy. Probably the most talked about one is one by Congresswoman Sarah Jacobs out of California called the My Body, My Data Act. It's actually kind of similar to some of the other bills, but it just references reproductive health care. Again, with the party split and the chamber split, it's unlikely that we'll see any of these specific bills to reproductive health move, but maybe some of the other bills could see some movement.
Yeah, and I think the interesting thing to note there would be, even if we can't get something that's specific to reproductive health, if you focus on the general privacy law, a lot of the concern around some of the current digital health products is in the direct-to-consumer space, the data that they're collecting and utilizing falls outside of HIPAA because they're not covered entities. By going direct-to-consumer, not taking insurance, just having you pay out of pocket, they kind of fall into, I don't know if it's a gap or just a limitation of how HIPAA was enacted back in the mid-90s, where it was focused on, call it the traditional healthcare industry, and now you've had this broader surrounding kind of healthcare marketplace arise. So even though there's, I would say, probably broad consensus that something has to happen, or not has to, but should happen on privacy because we don't have one set schema for regulating privacy in the US, there's a lot of tension within Congress, and for the broad ones, you have the states that have taken action, actually seeking to block or say that whatever Congress would pass isn't going to preempt the states because they like what they've passed in their own states. California being one of the bigger examples of that because they're kind of fully embracing the California Consumer Protection Act, and then the CPRA, which is the new one, which acronym I'm blanking on at the moment, or what the acronym stands for at the moment. But there is that kind of tension where the members of Congress can be protective of their individual states, which is kind of bringing us over into what have the states been doing. So this map kind of showing what some of the laws might be is probably out of date at this point. I think we sourced it from January, back when we were putting finishing touches on the slides, and just given the nature of things, there's been a lot of action. Probably the most notable one is Florida should be colored in at this point in time. The news was last week that they passed a 6-week ban, so severely restricting access to services. Then other states, even if they had bans, they've been expanding expanding upon those restrictions. There is Idaho with not facilitating a minor to be able to travel, so kind of the key is there's constant action happening at the state level. So whichever state that you might be in or that you might be operating in, you need to kind of be tracking what's happening from a legislative perspective there. Again, it's an opportunity to engage in the process. Just a lot of, maybe not companies, but some organizations will have legislative committees within them that seek to comment on proposed laws, or have resources you can use if you want to be able to go up and speak to, a representative or a state senator on a particular issue. So in addition to state legislative bodies getting involved, you also have the courts in individual states considering issues related to abortion and reproductive health. So in January, you actually had an interesting divide, or not divide, kind of opposing decisions arise in 2 states where, in one case the decision was probably expected, and the other the decision was relatively unexpected. So in Idaho, you had the Idaho Supreme Court upholding laws prohibiting access to abortion, whereas in South Carolina, they struck down a state law finding that in their state constitution, there were privacy rights that would enable that right to choose. Since then, there have been a couple other states weighing in on the issue, again, interpreting state law and state constitutions, which can obviously differ. In Oklahoma, they allowed access if the person's health is at stake. So essentially reading in to protect someone, protect the mother's life or the woman's life, if they're presenting an abortion is determined necessary. It didn't rule specifically though whether there was a specific right that existed under their state constitution. North Dakota upheld an injunction. The state Supreme Court there upheld an injunction on enforcing a new abortion ban, finding an implicit right to obtain an abortion to preserve life or health under the state constitution. Again, didn't necessarily go the step of saying there is a full right, but there is some degree of protection. And again, so there's a lot of nuance on a state-by-state basis so you won't necessarily be able to predict a particular trend or be able to assume an outcome based on where a challenge is being raised in a particular state.
So we also wanted to just quickly focus on a few discrete areas that are different in different states. So first, talking about telehealth delivery. So even prior to the pandemic, some providers were using telehealth to expand the reach of reproductive health services, including access to medication abortion. So that would work where a physician would help supervise the 2-drug regimen, Miffy, and then another drug called misoprostol, or I'm not saying that right, but Miffy and miso, and those would be taken within 24 hours of each other, but a physician could be on call using telehealth to help with that procedure. But even pre-Dobbs, a lot of states were saying you have to do that in person, so that wiped out the ability in those states to use telehealth to expand abortion access. And additionally, some states, some providers were using telehealth to do counseling services. Under the Casey decision, which we talked about before, states were requiring waiting periods of up to 48 hours. And so what some providers were able to do is they would have a counseling session for the first part of the visit so that a woman didn't have to travel twice within 2 days in order to access abortion services. And then the other thing we wanted to know is there's a lot of ballot initiatives that have been happening. So in some states, not every state, citizens or the legislature can petition to put something directly on the ballot. And as Matt mentioned, some state constitutions already, either through judicial decision or sometimes explicitly recognize a right to an abortion. In the last election cycle, we saw several states, including California, Michigan, and Vermont, approve guarantees vis-a-vis a ballot initiative process to add explicitly this right to their state constitutions. We also saw a few states, notably Kansas and Kentucky, reject initiatives that would have clarified that state constitutions did not have, there shouldn't be anything assumed in the constitution of that state that would have guaranteed a right to an abortion. And it's still early in the election cycle. I love politics, so it's always following whatever's happening. But there are 2 states that have already put this on their ballots for 2024. So New York and Maryland have placed it. And then what is probably going to be most interesting is Ohio is trying to collect, advocates in Ohio are trying to collect signatures to be able to put it on their ballot for the next election cycle. And we should also note that in many states that do allow ballot initiatives, state legislatures are trying to curtail the ability to make it harder to add ballot measures vis-a-vis citizen action. There's been a notable increase. Obviously, I think the most famous ones are medical marijuana or recreational marijuana and Medicaid expansion, and now abortion access, and sometimes voting rights are going on ballot initiatives. So we're seeing a curtailing of citizen ability to do that.
Yeah, and I think, if there is a curtailment of that ability to seek ballot initiatives, that's going to obviously have ripple effects, because it's not just a curtailment on a particular issue, but making it harder overall to have ballot initiatives, which could have impacts on other policies. And then there might also be variation on a state-by-state basis. Like, I'm in Massachusetts, and if you have something passed by a ballot initiative, you actually then can't, you can't have a similar ballot initiative on the same topic for a certain period of time, so a few years afterwards. So I'm not I don't know what the rules are in other states, but that could also be something to be tracking if something does pass. People play, in Massachusetts, we see political games played with that when it comes to certain issues. Kind of further looking at the states, we've touched on this a little bit, and I think Oliver is talking about it with prescriptive practice, but there's a tension in the states about the interstate delivery of services. Again, we all don't think twice about traveling between state lines for really any purpose, but there are questions being raised of, can states introduce criminal penalties if someone leaves their state to obtain a service that's legal somewhere else that particular state doesn't want performed in its state? Or could it just prevent the travel altogether? Along with, can services be directed into the state? So, again, the mail delivery of medication, of medical abortion, or other reproductive services, because it's, it is being considered more broadly when you're talking about reproductive health, so it's maybe not just one particular issue. Then the other piece to keep in mind or to look at, and this kind of goes to our discussion about why it's important to look at general data privacy. In Nebraska, there was a case where the state, the law enforcement in the state obtained records from Facebook for messages contained in the Facebook Messenger app between a mother and her daughter because the mother was helping the daughter obtain an abortion. They use their criminal enforcement tools to obtain those records. By putting it in Facebook Messenger, clearly not going to be protected by HIPAA because it's a private exchange, or was assumed to be a private exchange between two family members, and it's not going to invoke any of the protections or the process that HIPAA would require. So law enforcement can be very persistent in the use of its available tools of how it's going to enforce the laws. So paying attention to what protections could be added or what limitations. I do question, even though I mentioned with the NPRM for HIPAA that it's seeking to reduce or restrict the ability to access for particular purposes, I don't think in my view, you'll ever see a complete bar on law enforcement being able to obtain data, because I think there's always going to be some argument that you need some investigative ability on that front. So kind of with all that background, what does it mean for digital health? For those of us in that field, kind of the entire backbone of digital health is collection, generation, utilization, exchange of data. So what's going to be happening? So I think there's kind of a few ways to look at it. Obviously you're going to have to figure out what policy applies to you, but on an individual company by company basis, I think the first thing you're going to be looking at are how do you structure your terms of use and how do you structure your privacy policy. Those are fully, or well, I'm not going to say fully under your control, but those are mostly under your control. You can't draft things that are going to be contrary to law because you can't draft an illegal contract. It's not going to be enforceable. So you need to, again, consider what are the laws of the particular areas that you're working in, also what laws are applicable to you. You also don't want to misrepresent or how you're going to act in those documents. There's been a few enforcement actions recently from the Federal Trade Commission against healthcare entities that fall outside of HIPAA, but were making certain assertions within their privacy policies about how they're going to use or protect or not use data under their control, and then didn't live up to those promises. So from the FTC's perspective, that's what's called an unfair and deceptive trade practice, and then they can seek to engage in enforcement. But again, think about how you're structuring those. Think about what if you're in that space, what do you want your position to be as a company, and what steps as a company are you going to be willing to take in terms of responding to requests for data or not disclosing data in certain circumstances. That leads into what type of business are you? Are you engaging what's called B2B or business-to-business transactions? So that's in between companies. That is typically, or more often than not, that's how you're going to find digital health companies if they're not the direct provider of services, assisting, say, a hospital system and becoming a business associate under HIPAA. So then you have a clear understanding of what legal restrictions might apply. Contrast that if and the slide says, or the picture says B2C, or the other way to think of it is D2C, so direct to consumer. If you're direct to consumer, very often HIPAA is not going to apply, and then you're going to have to be looking at the hodgepodge of state laws, if they even become applicable to you, because a lot of them have thresholds before they begin to kick in. Again, using California as an example, you have to have certain revenue thresholds, it's about 25 million, which a lot of startups are not going to be anywhere near that for a long time, along with records about a certain number of people, and I believe that's about 50,000 individuals or households in California. So again, a pretty high threshold. So people might think a lot of protections apply, but they're not fully applicable yet. And then the last piece to think about is, and this got a lot of attention through Google, but geolocation data. So a lot of apps, when you download it, you probably don't think about it, but if you have an iPhone now, or if you have an iPhone that's up to date, I should say, a lot of times you'll be asked when you open an app, how do you want to allow it to know your location? And that data gets stored, and that can be used in a lot of different ways. It can, so one step was Google said we're only going to restore that data for a certain amount of time. True or not, I don't think you've figured it out. But also, apps will often ask for broad permissions, even if if the app doesn't need all that information it's collecting. But again, that's going to be obtainable in a lot of instances. So I think there has to be thought given in terms of what actually should be collected, how long should it be retained, and again, that then feeds into what protections might be available under a particular law. So do you want to lead off with the counseling and then?
Yeah. So we also wanted to just highlight some of the conflicts and amalgamations between law and medical judgment and how obviously the two can conflict. One of the area that we wanted to highlight, again, I mentioned before, there's counseling services. Some states require that as part of a two-step process with a waiting period prior to Dobbs. But, one of the things that people talked about from the pandemic is, how much telehealth got used, particularly for therapy, mental health services. And there may be need to do referrals, to do counseling, whatnot, where the issue of reproductive health services access is part of the reason that a patient is seeking to get counseling. That is a source of stress for many individuals and may come up as part of a counseling session. So in thinking about, how you're doing your mental health services, if that's, the type of provider that you are, how might you be affected by some of the state restrictions or state bans that are happening? We also wanted to know, the federal government under President Biden, who is supportive of access to reproductive health, like Matt said, has put forward this proposed change to HIPAA. That's for reproductive health services, but if, counseling or referrals need to come in through a different way, there's a question about will that be covered in this new regulation? So an area to comment on if you're so inclined.
Yeah, and then a couple other areas to think about are, for professional licensure. So for so for physicians, nurses, any professional that has a professional licensure required to engage in their profession, those are all issued by a state. There's no federal licensure for, any of those, for any of the medical professions. So looking on a state-by-state basis, I think this becomes a particular note for telehealth companies. A lot of telehealth companies seek to have their physicians or other clinical professionals licensed in many states. Some of them push for all 50 if that's possible, or whichever states they're operating in. A question could easily arise, if you're performing, if you're supportive of different services, legal in one state, illegal in another, the state where it's illegal might try to take an aggressive action and say, well, you're providing care, a type of service that we've said is illegal. We don't care if it's in our state or not, but we're going to pull they could theoretically pull that professional's license. In many instances, if you lose your license in one state, that's going to automatically trigger action in every other state where you have a license. So you could have this unintentional or potentially intentional cascade of licensure removal, which is going to have a lot of different repercussions for the individual whose license is being impacted. So I think that's going to be an open question. Related to that is kind of the introduction of medical legal questions within the delivery of care. Talking with folks that I know who are, I think in-house counsel at hospital systems, patients could present, and this is going to kind of go tie back to the discussion about EMTALA that we had earlier, where EMTALA is being interpreted to say you need to provide stabilizing care. You can provide any type of care that is called for under your professional medical judgment. Well, most people aren't going to, there are, a lot of people are aware of all these debates about what services are legal, what services might not be legal, and they're not going to want to do something that's going to potentially put them at liability. Then resulting in kind of these internal debates about, what's ethical, what's legal, what's permissible, and it can delay care, it could prevent care, or any other thing. So it's introducing a whole new layer of consideration before services proceed. So I think a lot of those issues are open, and it's not really clear how they're going to shake out. So kind of with all of that, where is everything going? I think it's a day-by-day determination to a large degree. Kind of as we were pointing out, within the past week, there have been developments and there have been changes, and there's stuff that will change tomorrow or the day after. So the only kind of certainty is that everyone needs to be paying attention to what's happening both on the federal and the state levels.
Yeah. Why don't we conclude there, because we have about 10 minutes left to take a couple questions.
So before we begin Q&A, I just want to say I want you guys to all go into your mobile app and fill out that evaluation, right? The aisle, there's 2 microphones. Please bring your questions forward. Let these guys have them. We literally have 10 minutes for Q&A.
I don't have a question, but the next time you do this presentation, I have a case study for you. So someone who reports to me called me one day after she had left her doctor's appointment. She was pregnant, and her doctor had just informed her that the test indicated that her baby may be deformed, or she may be carrying a stillborn baby. The geneticist decided that they wanted some more tests, and the test revealed that there were no problems. Well, her OBGYN had already told her that in the state of Texas, he would not be able to do an abortion for her, and the insurance may not pay for it, but he told her where she could go and have it done. Fast forward 7.5 months later, she called me after she had left the hospital because her baby was stillborn. Was it the provider that didn't supply the information, the fear of going to another state? Whatever it was, we have to clean it up because right now it's dirty, and we're losing babies and we're losing mothers.
Thank you.
I have a couple questions. I am the manager of virtual health at a large health system in Colorado, and based on that, I would like to know, is there a definition of reproductive health? We have maternal fetal medicine providers that do telehealth to other states, and I'm trying to understand if there's a restriction on telehealth or reproductive health. What does that mean? Do we know?
Yeah, so I think it's going to depend on what particular services you're looking at, because it's looking at using the HIPAA NPRM kind of as the gateway. Within the initial commentary to that, it recognized, OCR there recognized that reproductive health care or reproductive health services, I should say, because they were careful to say that they're using a new term, but reproductive health services do have definitions under Medicaid, and you're probably going to care more about Medicaid because it's the population of individuals who require reproductive health services with Medicare coverage is probably relatively small. It still possibly exists because you can have people on disability or other means of accessing Medicare before they're 65. So there are definitions there. If you're looking at Medicaid, that could potentially have state-by-state variations. So unfortunately, there is no easy answer without probably doing a deep dive into the particular states where your clinicians are directing their care. So I will go back to the easiest lawyer answer, which is it depends. That was, going back to law school, the first lesson that we got on the first day of orientation was that's how you answer every question.
My second scenario is we have genetics counselors that do virtual health out of state, and some states require genetics counselors to be licensed, and others do not consider them licensed professionals, so it's not as much of a licensing problem for them. And to my colleague's point that just shared, like, I'm concerned if I'm a genetics counselor and you live in Idaho or somewhere that's restricted abortion, and I share with you genetic information about your baby. Am I in some way liable for that abortion that you want to have? Or do we just have to wait for court cases and see what precedents get set? I guess I don't understand how these things get decided.
I mean, I guess my reaction, and feel free to jump in. It is unfortunately going to have a chilling effect in a lot of states. So it may be legal under First Amendment or whatnot, but are people going to want to take that chance? There might be some test cases or whatnot, but I think you're seeing it in a lot of states like Texas, Florida, where health professionals may not want to practice to the extent of their license because they don't know what the repercussions are. The Texas bounty law, does allow people to file a civil complaint to go after people who sort of like aid and abet on abortion services. So is that, there's the law school hypotheticals, like if an Uber driver takes somebody, like, are they part of that? So I think people don't know yet what the repercussions are. Like, what we're trying to get at is this has ripple effects. It's not just about one particular service. It's impacting a lot of other areas.
Yeah, and I think the only expansion I'd offer on top of that, to kind of go to the last question you're posing, is I think it will end up shaking out in the courts. Because I think you'll end up with different states enacting different laws that take different approaches. You've already seen certain states say, if, say, a state with a restriction tries to request information about what happened in our state, the state, certain attorneys general have said, you don't have to respond, you don't have to honor that request. So I fully expect that unless the highly improbable outcome of Congress doing something were to occur, you'll end up having courts deciding it, which really means you'll probably again have state-by-state divides, and ultimately, for better or for worse, it will eventually end up back at the Supreme Court to some degree. It seems like it's becoming harder and harder to figure out what the Supreme Court is going to do and whether the court will respect longstanding precedent. But if you're having questions about respecting state rights that way, hopefully that's one where it's easier for them to ignore arguable political viewpoints about the kind of the and just focusing on the overarching issue that's really the core legal question.
Hi, this is Rochelle Prosser from Orchid Healthcare Solutions. My role is to create a database that would house all oncology treatments, including drugs, predeterminate to FDA post-approval through phase 4. In listening to what you have proposed today, how do we as tech companies that aren't actually providing direct care protect ourselves from exposure? Should we house a drug or treatment option that is contrary to reproductive health, to birth? Because we know that in certain oncology treatments, they tell you you need to delay your reproduction. So then we, as healthcare providers, have to counsel our patients about preserving their reproductive function before they embark on the journey of taking care of their own health. So is it the egg? Is it the chicken? who has the actual civil right to provide protection of their own care. And as healthcare entities, as we think going forward, where we are not providing direct care, what is our exposure in just housing a specific treatment option that has great potential depending on what the state regulations are?
Yeah, so, I mean, I think it's going to require parsing through where exactly you fall under which particular regulations. And I think all the questions and all the points that each of you have brought up just underscores the fact that one decision has all these ripple effects without fully understanding all the consequences. It's kind of an axiomatic thing to say in healthcare, but it's you have to keep peeling back the layers, and there's always 50 extra layers beyond what you might have expected, if not more. And I think this is just further demonstrating kind of all the interconnections between different components of healthcare, and that theoretically, saying that a decision or choices are being, from a policy perspective, are being returned to the states. One, that's not being borne out, because you're seeing policy is being made still on a federal level, and proposals being made on a federal level, and conflicting views of the states. So it's putting everybody, regardless of which position that you take, in a tough spot, because you're not sure what is, at the end of the day, what is actually going to apply to what you're trying, what care is being delivered, or what care you're going to be allowed to deliver, or what's going to happen with all the data that you're holding. So it's, again, I think it takes going through in probably very fine detail of knowing exactly what laws or regs are applied to you, and then keeping track of everything that's changing, because what was true one day, a couple weeks later, might not be.